registrar got his assistant to send a letter reminding me and the mother of my child that we hadn't had our baby daughter registered. And this is what I sent. Declaration of denial of consent to register children. We, the authorised representatives for the legal persons, my straw man, and you haven't seen that name, but that's the mother of my children, do hereby declare that the following is a verified plain statement of the facts as we perceive them. Let it be known by all concerned, interested and affected parties that 1. We have been granted irrevocable superior guardianship rights over our children by the Creator of the universe. 2. We have accepted irrevocable power of attorney over our children's well-being and property until the 18th anniversary of their birth. 3. For and on behalf of our children, we have settled their entire legal estate into private trust, which is administered for their maximum benefit. 4. The property settled into said private trust includes, without limitation, any and all information pertaining to the existence of our children, strictly precluding the disclosure of the details of their birth to any party whatsoever. Material evidence demonstrating that any and all disclosure of information pertaining to the existence of our children would demonstrate a breach of the aforementioned private trust, and all those parties responsible for said breaches will be liable for charges of £30,000 sterling or functional currency of the United Kingdom per occurrence. 6. We do not recognise or consent to any perceived obligation, whether statutory or otherwise, to register the births of our children under any circumstances whatsoever. 7. As trustees of the aforementioned private trust, we affirm jointly and without division that we refuse to grant or consent and or authorisation to the registrar or any other individual, organisation or legal entity to register information pertaining to the birth of our children under any circumstances whatsoever. Declaration. We, the undersigned, hereby affirm to the very best of our knowledge the entirety of the foregoing is true, correct and not misleading. In the geographical area of annuity upon crime, this declaration is autographed, sealed and date stamped by the post office on the 10th day of the month of May in the year known as 2010 AD. Now, obviously, they like that about as much as the tax man liked theirs. And around about the same time, Amit also became a father, so he started the same process.
The difference that I did was where Michael responded to a letter, I actually we sent the declaration within, I think it was around 3 weeks of my daughter being born. So we sent it straight to the registrar. We sent it straight to the registrar of our local county, and then we got a letter back, which I think is a similar one to what you got, which is a notice requiring a qualified informant. I love the wording. To give information for the registration of a birth. Now, in this notice, by the declaration that has been drawn up, they have actually already made breaches by quoting the name of quoting that somebody was born on that date. Yeah. So from there, we sent, and I think Michael did the same thing. We sent a conditional acceptance. Dear Caroline Short-Tempered, following receipt of your notice dated, whatever the date is, and pursuant to the enclosed notice of appointment, I hereby serve notice of conditional acceptance, wherefore mother strawman and father strawman agree to register the births of their children in the most expedient manner possible upon receipt of the following items. Number 1, material evidence demonstrating that mother strawman and father strawman have not been granted irrevocable superior guardianship rights over their children by the Creator of the universe. I feel that's going to be a very difficult one for them. Number 2, material evidence demonstrating that mother strawman and father strawman have not accepted irrevocable power of attorney over their children's well-being and property until the 18th anniversary of their birth. Number 3, material evidence demonstrating that the information requested has not been settled into a private trust, precluding the disclosure of any and all details of their children's birth to any third party whatsoever. And you don't. It's a private trust, it's not something that you are lodging into the public, so there is no need for there to be public notice of that trust existing. Yeah. Does that make sense? Material evidence demonstrating that all disclosures of information pertaining to existence of their children would not represent a breach of the aforementioned private trust, as well as what Michael's been talking about earlier, the laws of equity. Material evidence demonstrating that all those parties responsible for said breaches would not be liable for charges of £30,000 sterling or functional currency of the United Kingdom per occurrence, as is mentioned in the original declaration. Number 6, material evidence demonstrating that the mother strawman and father strawman have consented to the statutory duty prescribed by the Birth and Death Registration Act 1953 without which no sustainable cause of action for prosecution can arise. Number 7, material evidence demonstrating that mother strawman and father strawman have not unequivocally denied their consent and or authorisation to the registrar and or any other individual, organisation or legal entity to register information pertaining to the birth of their children under any circumstances whatsoever. Number 8, material evidence demonstrating that your statement that, and this obviously depends on what you may receive, the female child was born to mother strawman on or about the date, does not represent 2 clear breaches, obviously depending on the letter, my one it was just 1 breach, of trusts by the registrar of births and deaths. Number 9, material evidence demonstrating that any and all attempts to enforce statutes upon persons who have not consented to perform under said instruments would not represent fundamental breaches of international human rights laws as well as the laws of nature. Please find enclosed a certified copy of Declaration of Denial of Consent to Register Children, which was the original declaration that was sent originally in the first place, and then the usual 7 days failure to deliver an appropriate response will result in lawful presumption that the non-negotiable conditions cannot be met and that your request has been duly withdrawn with no further action required without malice, mischief, or wilful voluntary vexation since 17. So we both got this from the Home Office Identity and Passport Service, General Register Office at Smedley Hydro, Trafalgar Road, Birkdale, Southport. It says personal with the address on there. Dear Mother Strawman, report of an unregistered child by the Registrar of Derby Registration District. The above registrar has reported that the birth of your daughter born on the date has not been registered despite the issue of a formal requisition asking you to do so. It is the statutory duty, which Michael will go into in this next letter, of a parent to register the birth of a child within 42 days of the birth, and failure to do so is a punishable offence. What's the punishment?
A fine of £2 per occurrence.
Oh, occurrence as well, so you have a lot of kids.
Births and Deaths Registration Act 1953.
The registrar has been instructed to send a further requisition asking you to give information for the registration of the birth at the registry office, which will be the local registry office. Please note that if you give information to any registry office in England and Wales, you can. If you do not attend to register your son's birth, now I didn't have a son, we had a daughter, they mentioned a daughter earlier in the letter, we have to say it's a son, so but the Registrar General will have to consider what steps must be taken to meet the requirements of the law. I must emphasise that if the birth is not registered, the child will be unable to obtain a birth certificate, which will cause considerable difficulty in the future. Reply.
Yes. Following receipt of your letter dated 11th of June, the contents of which are refused to cause on the basis that you have failed to respond appropriately to the notice of conditional acceptance dated 27th of May, for on behalf of Strawman, I hereby serve notice of opportunity to cure dishonour, wherefore in good faith Mother Strawman and Father Strawman agree to register the births of their children in the most expedient manner possible upon receipt of the following items. Now the first are just the ones that Amit's already listed, and Number 3 was slight amendment. Material evidence demonstrating that the information requested has not been settled into a private trust, precluding the disclosure of any and all details of their children's birth to any third party whatsoever, unless that action is of significant benefit to the beneficiaries. They have to demonstrate the benefit. Ask the registrar what the benefit of registration is, and they can only tell you what their benefit is, but they don't want it. So they can't say anything. They can't even say to you, most people, including us, we thought that since 1983, since there was a statutory instrument passed in 83, everybody needed to provide their child's birth certificate to get a passport. Not the case. If the parents are both UK or deemed UK citizens. And if you have an NHS number, well that would seem to be more evidence that your child is qualified as a citizen and therefore has to be given a passport upon request by the Guardian. Therefore, what's the downside here?
Just try and find anywhere anything that tells you why do I have to register my children. All you will find at every point is you have to do it because it's law. Which to me, and I'm sure to all of you as well, isn't really a just explanation.
I haven't been able to find one single prosecution